Good afternoon, ladies and gentlemen. Welcome to Dr. Olu Asekun podcast. Today is another beautiful Wednesday. Thank you for joining us today. We have a lot to cover today, a lot. This new administration is a roller coaster. And I thought that we'll be able to catch up, but am I not going to see it on the screen? Okay. I thought we'll be able to catch up, but as much as we try, they keep rolling it, new policies, new programs, new executive orders every single day. So today, we'll be talking about the latest development between last week when we had this podcast and today. It's very, very interesting because USCIS is doing something that they have not done in my decades of legal practice, of immigration practice. They have started doing something they have never done. So we are going on a very interesting journey today. I'm going to give you a few minutes. Please invite your family, friends, colleagues at work. We have a lot to discuss today. Before we start answering questions, I can see that questions are already rolling in, but we are going to give an overview because there's a lot of new developments. So if you have questions, start sending them in. But in the meantime, we need to discuss all the latest developments. On Friday, February 28th, USCIS rolled out new set of forms, new set of application forms. That was late Friday. They rolled out new set of application forms. Application for permanent residence, I-485. Application for citizenship, N400. I think I-824 was also part of it. Application for U visa.
The supplement A.
Yeah, the regular I-485 application, that is application for green card. The supplement A that we use for 245I, that virtually major forms. They rolled out new forms. And what they did, which they have never done since I started practicing immigration law, and I've been doing this for decades, what they did was that the forms were rolled out on Monday and effective the same Monday. If you file any application without using the January 20th edition, which is the one that was rolled out on Monday, your application is going to be rejected. Normally, whenever USCIS is proposing a new form, they give us advance notice. Whenever USCIS roll out a new form, they give us grace period. They will tell us, okay, this is the new form. We will continue to accept the old form for until so date. Maybe they give us like a month notice or 2 weeks notice. But this time around, the forms were rolled out on Monday with a date backdated to January 20th, and the form was also effective the same Monday, March 3rd. So what that means is that if you had mailed in an application for permanent resident on Friday, your application is going to be returned. It's going to be rejected. And the painful part is that if your application is time sensitive, especially for employment-based petitions, people are going to get into trouble. People are going to get out of status. And USCIS doesn't seem to care. I don't know what American Immigration Lawyers Association is going to do about it. I see that I tried to call them yesterday and they informed me that they have received numerous complaints from lawyers. I don't know what they are going to do about this, but if they don't challenge it, a lot of people are going to get into trouble, especially a lot of do-it-yourself people. The funniest thing is that even when USCIS is going to return forms or reject applications, they don't do it by express mail. They don't do it by trackable mail. They post it by regular mail, and they don't do it immediately. So even all the applications that are going to be rejected may not be received until 1 month's time. So you can imagine how people are going to get out of status. This is extremely painful, but USCIS seems not to care. This administration seems not to care. They don't give a damn. Anyway, we will wait and see what American Immigration Lawyers Associations are going to do. It is possible, I'm not sure yet, but it is possible that this will be challenged in court, because you cannot roll out new form and then tell people that the forms becomes effective immediately and prior versions are no longer acceptable immediately. No notice, no prior notice, not even 48 hours notice, no notice. This is unprecedented. Again, we will see how it goes. But if you mail in your application recently and you have not received a receipt notice, I'm not sure whether or not you will be affected, because we still don't know how USCIS is going to handle that. But if you just mail in your application and immigration is going to receive it from this week, that one is already certain they will reject it. So you have to brace up. You may need to consult your attorney if you are in this situation, because you may need to repackage a new application and send it in using the new form. Otherwise, especially if you know that your situation is time sensitive, please contact your attorney so that you can address this as quickly as possible. Again, like I said, USCIS rolled out a completely new set of policy that same Friday, last Friday, February 28th. And one of the policies they rolled out is affecting what we call NTA, notice to appear. Notice to appear. Now, a lot of people may not understand what a notice to appear is. Notice to appear is the charging document. That is what instigates removal proceedings. Notice to appear is what instigates removal proceedings. So if anyone is going to be placed in removal proceedings, what we used to call in the past deportation, if anyone is going to be placed in removal proceedings or placed in deportation proceedings, the starting point is the issuance of a notice to appear. That notice to appear is what USCIS will file with the immigration court, and then the immigration court will register it and then issue hearing notice. That is the beginning of notice to appear. Notice to appear is what normally contains the allegation that is leveled against the foreigner. Usually, the notice to appear usually have things like you are not a citizen of the United States, you are a citizen of so country, you entered the United States on or before so date with authorization to remain until so time. You remain in the United States beyond the period authorized. That used to be the regular content of a notice to appear. But under the new policy that is rolled out on Friday, immigration can now issue notice to appear and level allegation of fraud. They can now issue a notice to appear and level allegation of criminal activity. They can now issue a notice to appear and level allegation of suspicion of terrorist-related activities. Now, there are 3 agencies or sub-agencies that can issue notice to appear. USCIS can issue notice to appear. CBP, Custom and Border Protection Officers, can issue notice to appear. ICE, Immigration and Customs Enforcement, can issue notice to appear. So now this new policy is giving mandatory instructions on when to issue notice to appear. And this is a little scary. Now, the first thing that the policy highlighted is that for the purpose of service of notice to appear, immigration is going to consider the last any notice to appear that is mailed, that is attempted to be delivered to an alien at the alien's last known provided address. That will be sufficient for the purpose of service. Let me explain it differently. What this new policy is saying is that even if you did not receive the notice to appear, it will not matter. What will matter is that there must be an attempted delivery of the notice to appear to your last known address. In other words, if your address is 5020 Mansfield Road, Arlington, Texas, and that is the last address you provided in the application you submitted to immigration, if they mail that notice to appear to that address, even if the notice to appear is returned as undeliverable, it will not matter. For as long as that is the last address you provided to them. This is going to be problematic, really, really problematic, because normally when people don't receive a notice to appear, the immigration court, will order the respondent removed in absentia, because all that the DHS will need to prove is that the notice to appear was mailed to this alien. But in the past, before this new policy, we are able to file a motion to reopen and convince the immigration court that the alien did not actually receive the notice to appear. I mean, what if somebody lives in an apartment where there are issues with mail delivery? I mean, there are some apartments where they have mail stolen. There are apartments where they don't lock the mailbox, and sometimes mails are delivered and it is picked up by somebody else. A lot of things could happen to prevent somebody from receiving a mail. So, but this new policy is saying that all that will not matter. What matters is that the notice to appear has been mailed out to the last address they have on record. Whether you receive it or not, that is immaterial under this new policy. Now, the policy also explains under what circumstances a notice to appear will be issued. There are several categories of the circumstances. I'm going to start with the first one. I wrote some of them down so that I don't miss out any of them. Now, the first one, under the first category, if you file a removal of condition, I-751 or I-829, if you file it and it is denied, those are statutory requirements. So the first category of notice to appear, I will call statutory requirement. Statutory requirement. There are only three categories of statutory requirement. If you apply for a removal of condition, if you have a conditional green card and you apply for a removal of condition and then that removal of condition is denied, it is mandatory under the law that immigration must issue notice to appear. There are two types of conditional green card. 751 based on marriage to a U.S. citizen if your marriage was less than 2 years at the time the green card was approved. And I-829 as an immigrant investor, you get a initial conditional green card And then when it is 2 years, you apply to remove the condition and show that you actually comply with all the eligibility requirements, that is employment creation and all the other eligibility requirements. So you must prove all of that in order to get the 10-year green card. So USCIS is saying that if your I-751 or I-829 is denied, because it is mandatory by law for them to issue NTA, they will go ahead and issue the NTA. They will not exercise any form of discretion for that purpose. The third category of NTA that is mandatory is for people who file an application for asylum. So if your asylum application is not approved because USCIS by law does not have the authority to deny it, NTA will be issued and a referral notice will be issued. So those are 3 statutory required notice to appear, and that is the first category. During the Biden administration, even though all these 3 categories are statutory, it was only in the case of asylum that was enforced under Biden administration. Even the cases of asylum that were enforced, when people get into removal proceedings and then they realize that the asylum application is weak, sometimes the DHS at the time will terminate the case or dismiss the case rather than go ahead with the hearing and then order the respondent removed from the United States. But under this new administration, that is no longer an option. So they are saying that if you file an asylum and the application is not approved by USCIS, it is now mandatory and they are going to implement it to the letter. They are going to issue a notice to appear for you. Even if you withdraw your application, they will still issue a notice to appear. That is the first category under this new policy. Now, I'm going to go into the second category under the new policy. The second category talks about notice to appear in the case of national security. Notice to appear in the case of national security. This is a little scary because this policy is not even talking about conviction. It's not talking about criminal conviction. It's talking about mere suspicion. Suspicion. I mean, anybody can be suspected of anything. I remember anywhere in the world, one of the major fundamental principles of criminal justice is that an accused person is presumed innocent until proven guilty. But this policy is changing that. This policy is saying that once you are suspected of terrorist activities, notice to appear will be issued. So who determines whether you should be suspected or not? I mean, what evidence are they going to rely on? Because this is not talking about conviction. What if you are suspected wrongly, especially in a country where there's so much hatred? What if somebody does not like your face and report that they suspect you of criminal activities or of terrorist activities? In the past, I've had clients who were reported to immigration on the suspicion of terrorist activities simply because this person resigned to work with a different employer. And the employer wrote a letter to immigration accusing this person, my client, of terrorist activities. Luckily, the government decided to investigate it before arrest. So they investigated it and they realized that it was false accusation. So rather than arrest my client, they actually arrested the employer and they sentenced the employer for filing false information. But under this new policy, they are saying that mere suspicion is enough. This is really scary. So it simply means that if I don't like somebody, I can just accuse that person of terrorism And then guess what? The person is going to be picked up, the person is going to be deported. This is really scary. And I hope that American Immigration Lawyers Association are going to do something about it, because these are cases, in my opinion, that I believe that warrant litigation. Somebody needs to go to court and challenge these people. They cannot just keep violating constitutional rights of people in the name of enforcing immigration law. This is pathetic. I would have taken up the case personally, but there is something in law called local standard. I will not have any local standard. For me to have any locus to sue the government over this, I will have somebody who has been arrested on that basis first. So I cannot just go to court. Otherwise, I will have done it. This is really scary. Somebody can just be labeled a terrorist at the snap of a finger, and then the person's life will be destroyed just because somebody does not like your face. Anyway, let us continue. The next one under the notice to appear is criminal activity. Criminal activity, again, under this new policy, arrest for any criminal activity is enough. You don't even need to be convicted. Once you are arrested, that is it. They can issue notice to appear. Even if you are eventually found to be, if the allegation against you was eventually denied or dismissed, you will have faced deportation. So, my people, this is the time to avoid anything at all that can lead to arrest. If you are listening to me and you are one of those people who drink, maybe you want to suspend drinking for the next 4 years, or maybe 3.5 years now. Maybe you want to suspend drinking. Anything that can bring you to the attention of these people, anything that can lead to criminal arrest, if you have a ticket, just go ahead and pay it. Don't wait until that ticket leads to arrest. Don't wait until you are stopped by the police and then they see that you have a warrant of arrest on you. Don't wait until you are stopped by the police and they see an unpaid ticket. Don't wait until anything at all brings you to the attention of the police or any law enforcement. Because under this new policy, they are saying that anyone accused, not even anyone convicted, anyone accused of any criminal activity, notice to appear should be issued. We are in a very, very dangerous time. We are in a dangerous time. The next one is what is called fraud and misrepresentation. Fraud and misrepresentation. Under this new policy, they are saying that if immigration deny any application or petition and they suspect fraud, they must issue notice to appear. Again, this is a little scary because we have seen immigration in the past make false accusation of fraud. We have seen cases that immigration initially thought were fraud, and it turns out that they were not fraud. I have litigated so many cases against USCIS where they would deny my client case and accuse the client of fraud. And then we will go on appeal and prove that there was no fraud. But guess what? This new policy is saying that mere suspicion of fraud is enough. Mere suspicion of fraud is enough. And guess what? Who makes that determination? The officer. The officer. So it simply means that an officer can do and undo. They are giving adjudication officers, USCIS adjudication officers, CBP adjudication officers, ICE adjudication officers, they are giving them unprecedented power. Power that is contrary to the Constitution. power that is contrary to our fundamental rights in this nation. I'm beginning to doubt the rule of law in this nation. America is known to have been built on the rule of law. And what does the rule of law mean? It means that no one is above the law. But we have seen this administration show day in, day out that they are above the law. And they are being backed up by the Republican Congress. Because nobody seems to see anything wrong in what they are doing. This is fundamentally wrong. You cannot deprive somebody of liberty based on mere suspicion. You cannot deprive a family of togetherness, unity, based on mere suspicion. And that is exactly what this new policy is calling for. Mere suspicion. I'm going to go on because we have to. I know that there will be tons of questions by the time I'm done, but I need to quickly go over all these new policies. The next one on the list of notice to appear is the TPS, Temporary Protected Status. At least on this one, immigration agree that the policymakers agree that NTA for TPS holders should be based on a case-by-case basis. It is a discretionary matter that should be based on a case-by-case basis. That is for TPS. Is going to be based on a case-by-case basis. The next category of people that will be receiving notice to appear, they are people whose applications or petitions are denied. Now, if you file an application and your application is denied, it doesn't matter any type of application, whether a change of status to student, whether an extension of your B1, B2, whether application for green card, whether R1 application, whether H1B application, whether P visa, whether O visa, any application at all. If you file it and that application is denied and you are not in legal status, notice to appear is going to be issued. Still under this category, they are also going to start issuing notice to appear on people who are not in lawful status. If you are not in lawful status, even if you have not filed anything, notice to appear can be issued against you. So those who are not in lawful status, they are target for notice to appear. Again, for the purpose of those who are just joining us, notice to appear is the originating document. It is the instigating document that triggers removal proceedings, or what we used to call deportation proceedings. Notice to appear is that document that will tell you what the allegation against you is. Usually in the past, the notice to appear will only have about 4 or 5 allegations. You are not a citizen of the United States. You are a citizen of so-so country. You entered the United States on or before so-so date with authorization to remain until so-so time. You remain in the United States beyond the authorized period. That is what used to be the content of a notice to appear. But right now, under this new policy, they have stated that the notice to appear should include allegation of fraud or misrepresentation. It should include criminal activities. It should include all kinds of allegations that trigger your removal from the United States. So, and I'm listing all the categories of people or instances where notice to appear is now mandatory, has to be issued according to the new administration. So the next one, after the unlawful presence, the next one is what is called special circumstances. Special circumstances. notice to appear will still be issued in some special circumstances. There are things in the past that does not trigger notice to appear. But under this new administration, they are saying that these things are going to trigger notice to appear. One, if you have a green card and you file what is called I-90. I-90 is the application to replace your green card. If the application is denied, they are going to issue notice to appear and put you in removal proceedings under this new policy. So they are saying that if you file an application to renew your green card and that application is denied, they are going to issue notice to appear. Secondly, they are saying that if you obtain permanent resident, if you obtain green card, and they found out that at the time that the green card was approved, you are not admissible, then they are going to go back and retroactively issue notice to appear. Let me give you an example of that. Maybe you have an immigrant petition filed on your behalf by your U.S. citizen parent, especially U.S. citizen petitioning for unmarried children. Now, if the process went through and you received the visa, the immigrant visa, but before entering the United States, you decide to marry, maybe you have a boyfriend or girlfriend or a fiancé who is now afraid that if you go to America, you may abandon the relationship. And because of that, they insist that you get married before coming to the US. By law, that marriage will invalidate the petition. But because immigration does not have a way of knowing that you are married, you remember you already got your immigrant visa and you got married and then you entered the United States. It may be when you apply for citizenship. It may be when you attempt to petition for someone else. But what this new policy is saying is that at any time that they found out that when you enter the United States, you are inadmissible, notice to appear will be issued and you will be placed in removal proceedings. That is what the special circumstances is talking about. Now, every case is different, but this may actually be something positive because during Biden's regime, we had a lot of clients who were actually eligible for immigration benefit if a notice to appear was issued. And this is an example of them. But because the Biden administration was not issuing notice to appear to people without criminal record, we were unable to get them those relief. So for people in that category, this may actually be a positive news. However, before you jump at it, let me remind you, to be eligible for that kind of relief, using the example that I just cited, maybe you have a U.S. citizen parent who petitioned for you as an unmarried child of a U.S. citizen. Then you got married, and subsequently you obtained the visa. After you obtained the visa as your married child of a U.S. citizen, and then you got married before entering the U.S., because you are inadmissible at the time you enter, that green card is supposed to be void. And under this new policy, you will be placed in removal proceedings. But what I'm saying is that in such a situation, if your parent, who is a U.S. citizen, is still there at the time they place you in removal proceedings, you may be eligible for what we call a waiver under Section 237A1H. Another category, unmarried children of permanent residents. Maybe your parents are permanent residents and they file a 130 petition on your behalf. Although it took so much time, but eventually you got the green card, you got the immigrant visa. And before you entered the US, you decided to marry your fiancé or your boyfriend or whoever. By law, whenever a child of a permanent resident gets married, that approved petition is terminated by operation of law. This is because a permanent resident cannot petition for a married child. Only a U.S. citizen can petition for a married child. So in the case of a U.S. citizen, if you get married before your petition is approved, the petition will not terminate. It will change category. The petition will change from unmarried child of a U.S. citizen to married child of a U.S. citizen. It will take longer, but the petition will still be there. But in the case of permanent resident, if you get married, as soon as you get married, that petition is terminated by operation of law. So there is nothing, the petition is dead, terminated by operation of law. But again, if you are able to conceal that marriage from immigration and you are able to get into the US, again, it means that at the time of your entry, you are inadmissible. And according to this new policy, you will be placed in removal proceedings. But what I'm saying is that if you are in that category and you still have your parent, either still as a permanent resident or as a U.S. citizen this time around, you may be eligible for what is called INA 237A1H waiver, which will enable you to keep your green card and still be eligible for citizenship. So that is where we are. Still talking about special circumstances. The next one I have on the list is those who file asylum application and then they decided to withdraw it, even though they have not been invited for interview. They decided to withdraw it. So under this new policy, the policy is saying that notice to appear will be issued when you withdraw your asylum application, whether you have been interviewed or not. So it is one of those special circumstances where a notice to appear will be issued. The next one on this list is those who are paroled into the United States. If you are paroled into the United States and then your parole is expired, normally when someone is paroled into the US, they are paroled for a specific number of weeks, days, weeks, months, or years. But I've never seen a parole that is more than 1 year. But usually they are paroled into the US for months or years. So what the policy is saying that if you are paroled into the US and your parole has expired and you have not gotten any legal status, notice to appear must be issued. Notice to appear must be issued. The next one and the final one is what is called prosecutorial discretion. Now, you see, it's funny. This policy is creating the impression that there will be prosecutorial discretion, whereas the condition that they are attaching to it is almost going to make it impossible for any officer to issue prosecutorial discretion. So what the policy is saying that an individual USCIS officer, a CBP officer, or an ICE officer can actually use their discretion to decide not to issue notice to appear. However, if they decide not to do that, they must meet two conditions. Number one, they must get the permission of their supervisor. The supervisor must agree that, oh, okay, looking at the circumstances of this case, let us not issue notice to appear. The supervisor must agree to it. The second condition is that they must record it. It must be recorded in the system. And the officer must explain in the recording why he or she decides not to issue notice to appear. Let me tell you, under this current administration, with what Elon Musk is doing, I can guarantee you that no ICE officer or CBP officer or USCIS officer will exercise this discretion. Because the moment that they will have to explain why they are doing so, I don't know what explanation they will give that will not be contrary to Donald Trump's policy. So, if they are looking for people to dismiss, those people may be on the list. So I don't foresee any officer exercising that discretion. But again, the policy also have that aspect, creating the impression that officers can use their discretion whether to issue NTA or not. Okay, there's a lot to cover today, so I see that there are a lot and lot of questions. So I'm just going to, because if I continue, I may end up not answering any question at all. And I see that a lot of questions have come in. Is that the first one on there? Okay, let me read it from the screen. The first question today. Hi, doctor. I got my green card via EB2, Schedule A. What does PT mean? Part-time? I don't understand that. In 2022. Schedule A is, there is no EB2 Schedule A. I mean, people try to create the impression that they understand immigration law by abbreviating. There is no EB2 Schedule A. There are only two parts of EB2. Maybe they mean Part A.
Yeah, probably.
Okay, maybe they mean Part A. That is national interest waiver.
Yeah.
Part A simply means national interest waiver. Okay, let me assume that is what this one is saying. I got my green card via EB2 national interest waiver in 2022. IA-24 was approved March 2023 for my wife and kids in Nigeria. Case DQ. Okay, documentarily qualified by NVC June 2023, but no Lagos interview for 21 months. Can I file writ of mandamus?
Oh, okay. So it says that Schedule A occupations. but they
No,
don't-
that's what I'm saying.
Yeah.
That's not what this person mean.
Yeah.
He was just misusing the terms. He doesn't understand what Schedule A mean. I think what he wanted to say was Part A, which I assume
Yeah.
is talking about national interest waiver. Schedule A is actually talking about nurses and physical therapists. That is what Schedule A occupation is. So he is misusing the appellation Schedule A. He wanted to say probably Part A, which is national interest waiver. That's what I'm going to say. Well, you see, writ of mandamus is really complicated. It's really, really complicated. And if a case has been documentarily qualified by NVC for 21 months, in my opinion, it is eligible for mandamus. However, before I file mandamus, I will attempt to use, since you are here, I will attempt to use congressional intervention. If it doesn't work, then go ahead and file mandamus. But yes, 21 months, in my opinion, is a long time.
But it's normal.
What?
I mean, the time that it's taking them to call people for interview.
Yeah, but that does not make it right.
No, I get it.
Yeah, that does not make it right. Yeah, he's eligible to file mandamus. Please move the questions, please.
Yeah.
And let's act fast because we have just about 15 minutes left.
Was going to be our last question today.
Which one?
Uh,
Okay, yes.
where are we gonna stop?
Let me see. Okay, the last question I see here is the one that says on your next step interview. Is that the one you have? Okay, yeah. That will be the last question for. It says
Yes.
okay, yeah, that will be the last question from today because like I said, I'm not even sure if I will be able to answer all of this in 15 minutes, but I'll try my best. So the next question. Does a O2 holder supporting an O1 in the US have any restrictions as to applying for any one of the employment-based categories, or can they directly apply if they meet the requirement? Yes, they don't have any restriction. The only one that cannot change status in the US is anyone who enter with a visa waiver or anyone who enter with a J visa if they don't have a waiver of the 2-year foreign residence requirement. Those are the only ones that have limitations or restrictions. Yes, you can apply if you meet the requirement. Please move the question pretty fast. Hello, sir. Thanks for your voluntary update. God bless. Okay, thank you too. Good afternoon, Dr. Asekun. Thanks for your help. I filed an application for I-765 for renewal since November 2024. Will I also be expecting the new form? Well, no. Since you already have your application pending, the new form does not affect you. Please move it up, please. The next question. My green card is less than 2 years old. Can I travel to Canada to return in week without issues when returning? Well, this person didn't tell us how you obtain your green card. If it is obtained through marriage, you just have to be sure that you put your house in order before embarking on any trip. The next question. Hello, sir. Thank you for doing a great job. I filed I-140EB2 national interest waiver and it's been 402 days since I filed. It's still saying case is being actively reviewed. Is it anything for me to be worried about? Well, you have to look at the processing time. I don't know for now what the processing time for I-140 is. Can you please check for me, please? I-140 processing time. I'll go to the next question. Once we have the information on the processing time, we will let you know. If it is still within processing time, there's really no cause for concern. But if it is outside of the processing time, then you may need to do a service request. The next question, I-140 is I-140 EB2 national interest waiver. The next question, what is the current duration for U.S. citizenship application? I submitted my application 1 month ago and haven't received a receipt. Well, a citizenship application can be filed either electronically or by mail. So this person didn't tell us whether this one was filed electronically or by mail, because if it was filed electronically, you receive your receipt notice immediately. You receive the receipt notice the same day if it was filed electronically. But if it was filed by mail, it is not unusual for receipt notice to be delayed. Like I said, USCIS is not in the habit of mailing anything out with express mail. They don't do that. They usually do regular mail, and sometimes they don't send it out immediately. But there is nothing to worry about. It's not unusual. Although right now, citizenship application is being processed very fast, probably an average of about 10 months, 8 to 10 months.
So it's 14 and a half months. So they're really close to the end of the processing time.
Okay, can you please go back to that question? Let me see how long it has been.
412 days is what they said.
412 days. How many months is that?
14 is roughly 420.
Okay.
Yeah.
Yeah, we just checked the how many months again?
14 and a
13,
half.
14.
Yeah.
Okay.
14 months.
It's between 13.5.
Well, these days things is really confusing. You should have just
should be at the end.
converted it to months.
It should be at the end.
Okay, the processing time is about 14 months. So convert your 412 days to 14 months. So if it is less than that, then they are still within processing time, so you still have to wait. But they are very close. I think
Supposed to be 420 days.
that's 14 months. So I understand that 420 days is 14 months. So if your case is 412 days, so it means that they are very close to the processing time. So they are probably going to be working on your case very shortly. The next question. I'm currently on F1 visa, rounding up my MSc Mathematics degree by May 2025. I'm here with my wife. My wife plans studying nursing, but she can't at the moment because she's on F2. Please, yeah.
There's 3 parts.
I'm also a multi-talented musician who plays 5 different musical instruments. Is it possible to be on an O visa simultaneously with my F1 so my wife can change status to O2 so as to so as to be able to go to school. Well, I'm not going to have time to go into the requirement of O visa right now, but I'm going to tell you we have a podcast on O visa. So please go to our YouTube channel, look for our podcast, Dr. Olu Asekun on O visa. So you will see the requirement of O visa. If you meet the eligibility, then you can change to O visa. But let me tell you, once you attempt to change to O visa, the moment your application for O visa is approved, it means that you will no longer be on F visa, because the only way to get it approved is to apply for a change of status. So you cannot keep the two status simultaneously. You can only be in one status at a time. While your application is pending, you remain on F1. But whenever your application is approved, your status change to O status, and then your wife can be on O2. But the danger is, if your application is denied based on what they ruled out today, you will be placed in removal proceedings if you have finished your OPT for your F1 status. So you really have to look at the requirement of O visa carefully and be sure that you are eligible before you apply. This is not a time to do trial and error. This is not a period where you file an application if you are not certain that you are eligible. So I will implore you, take your time to listen to my podcast on O visa. Then you will be able to determine if you are eligible or not. Please go ahead. The next question.
That's one.
Okay. Next question. Sir, if you hired...
It's like if you're retained, that's what she wants to say.
Oh, okay, that's okay. Okay, so it means he wanted to say if you are hired. Okay. If you are hired, how
How
I'm
will you help someone?
okay, if you are hired, how will you help someone who has some inconsistency during his asylum interview with AO? Will there be a need for new statement declaration to submit? Well, this is a specific case. I cannot go into a specific case in a podcast. This is a specific case. If you want to discuss a specific case, then you will have to contact the office and schedule a consultation appointment. This
It's on the screen.
what?
Our information is on the screen on where they can schedule the appointment.
Okay, yeah, go to our website and schedule an appointment. The thing is, this podcast will use general information. We cannot discuss a specific case in a podcast like this. Even that would not even be good for you, because that would be exposing your information to the general world. I mean, for me to answer your question, I will need to ask a lot of follow-up questions and make a determination of how best to address your specific needs. So that is not something that we can discuss in a podcast like this. The next question, please.
That's all.
Okay. Good afternoon, Dr. Asekun. How does the EB4 visa having finished affect those that have already applied for green card and waiting for years? Well, if you have already applied for green card and your application has been accepted, then it does not affect you. It only means that your green card will not be approved until visa becomes available for you. But the fact that you have filed your I-485 and it has been accepted, that means that you are maintaining legal status. That also means that you can continue to renew your employment authorization until visa becomes available. The only thing USCIS will not be able to do is to approve your green card. Otherwise, it does not affect you. It only affects people who have not been able to submit the I-485. If your I-485 has not been accepted, then you need to find a way to maintain legal status. Those are the people that are affected. The next question. Good day, sir. I have a visa category R, B1, B2 from Nigeria. How can you have R and B1, B2 at the same time? I don't get it.
I think it's B1, B2.
So what does the R mean?
Maybe it was the typo.
Okay. I have a visa category R, B1, B2 from Nigeria, and at the point of entry, I was given 6 months that will expire in June this year. Can I travel to Nigeria and come back? Well, If you have multiple visa,
And this is part 2.
okay, yeah, let me first answer the first one before going to part 2.
No, it's just.
Oh, it's a continuation. Okay. Can I travel to Nigeria and come back in April or May and enter back before expiration date? I don't think this person understands the difference between a visa and I-94. Well, if you are listening to me, what I'm going to tell you, there's a difference between a visa and I-94. The visa is the one that was given to you at the embassy. That is the B1, B2 that was given to you at the embassy. That is the visa. That does not have anything at all to do with your legal status in the US. Now, at the port of entry, when you are given 6 months, that 6 months is what determines your legal status in the US, not your visa. Even if your visa is 5 years or 2 years, it does not matter. It is that 6 months that determines your legal status in the US. Now, if you go back to Nigeria, the moment you step out of the country, that 6 months that you are given, that 6 months is over. So it is not valid anymore because it is only relevant when you are in the US. It is not useful when you are outside the US. So even if you plan to come back, you cannot use that 6 months. That 6 months is gone the moment you step out. That is what controls your legal status in the US. Now, if your visa is still valid, you may be able to come back at any time before the expiration of your visa. But considering the fact that we are already in March, this person didn't tell us when he or she entered the US. I don't know how long you have been in the US. I don't know if this is your first entry into the US. I don't know if you have been coming in constantly. But the point I'm making here is that if you leave in March, or when did they plan to leave?
April, May.
Okay, if you leave April, May, the question, and you plan to come back, if the time is too close, at the port of entry, they may ask you, oh, you were here the last time for how many months? Tell us what you are doing for that long in the US and why are you coming back so suddenly? So you can be queried as to your intent. But if you have, let's say you have a 5-year visa that is still valid maybe for another 3 years, and you go back to Nigeria now, you may choose to come back next year. Yes, that is reasonable. But if you are here, let's say, even though you didn't tell us when you came, but I'm assuming that you have been here for 3 to 4 months. By the time you go back in April or May, you will have been here 3 to 4 months. So if you quickly come back, maybe come back in June or July, yes, they can raise issues at the port of entry as to your intent. What are you doing here? If you have a job in your home country, you should not be coming here and staying here that long. People that can come in monthly or every 2 months, or there are people who come in for business. Maybe you come in, you spend like 1 week, you leave. Yes, you can choose to come back the following month, do another thing, spend 1 week, and you go. But you must be able to answer the question, what are you doing? Somebody who came in and spent 1 week, it's so easy to explain what you are doing for 1 week than somebody who spent 3 months. If you spend 3 months or 4 months, you are going to have to explain what is it that you are doing. I mean, don't you have a job at home? Even if you have a vacation, you cannot have multiple vacations of 3 months, 4 months in the same year. I mean, it doesn't make a sense. It doesn't make sense. So you may need to explain if you decide to come back so shortly. But if your visa is still valid, you may come back next year. Yes, that is reasonable. The next question. We attended interview October 2023. Where? Okay, let me finish reading first. We attended interview October 2023. We have been invited for a second interview. The invitation is for I-130 and I-485 for me. What are we likely to expect at the interview? Well, there are multiple issues. Since this person is talking about I-130 and I-485, I-130 is a family petition, so I believe that this application is based on marriage. So what to expect is that there's something called talks interview. You may be separated and ask questions about your relationship. That is what to expect. It does not necessarily mean that there is a red flag, but remember, when I was talking about the executive orders that has been signed by the president, one of the executive orders is the one that talks about enhanced scrutiny, enhanced immigration scrutiny. So it may just be that the officer is complying with the enhanced requirement. On the other hand, it may be that there is a red flag in your case. So the simple solution is that the truth will always be constant. If you are living with your spouse, there's nothing to worry about. So truth will always be truth. If you live together, no matter the question they ask you, you'll be able to answer it. But a second interview usually indicates that it's going to be a stocks interview. It's likely going to be a stocks interview. 80% of the time, it's likely going to be a stocks interview. That is separation interview. The next question. Good day, sir. Thanks for all the information and updates you guys provide here. Please, I need advice for my husband's case. I'm a US citizen and filed for my fiancé in France and was denied due to criminal background he had years ago. He was advised to do marriage and to file again, which we did, but was still denied. Now we have a waiver case pending and he has relocated to Nigeria. What can we do for this kind of cases? We can cancel the waiver and refile marriage, or can he file just for a visiting visa? Well, based on the information you have provided, your husband is not eligible for a visiting visa. So the only way to deal with this is to pursue that waiver. However, waiver is not just granted in this type of case. This case, based on the fact that you have provided, this case requires that the U.S. citizen petitioner must prove extreme hardship. Extreme hardship. It is not a regular hardship. There's a difference between regular hardship and extreme hardship. Regular hardship is any hardship that is encountered by anyone who is deported or removed from the United States. It is common. Separation, of course, anyone who is deported or removed from the U.S. is going to be separated from their family. That is regular hardship. But because a criminal case is involved, you will need to show extreme hardship to the U.S. citizen. So that is what you need to put a lot of attention into, and probably it will be best if you hire an attorney who is well experienced in this kind of case. However, let me put a caveat. It is not every criminal case that is eligible for a waiver. It is not every criminal case. So your question did not tell us what the kind of criminal conviction. There are some criminal convictions that a waiver cannot fix. So you also need to be aware of that. However, majority of criminal convictions, waiver can solve it. But if the conviction has to do with terrorism, a waiver cannot solve it. If the criminal conviction has to do with aggravated felony, it will require additional things before a waiver can fix it. So again, you didn't give us that information, but my advice would be consult a well-experienced immigration attorney who can help you address the waiver. But without the waiver, you cannot get your husband into the U.S. If you follow everything we have been saying since, you will realize that even people who are already here, who have green card and they have criminal conviction, they are still subject to deportation. They can still be deported. So for somebody who is still outside and already have criminal conviction, it's not going to be an easy task to bring that person in. So my advice, consult an experienced immigration attorney to help you package the waiver application so that it can be approved. The next question, please. Sir, Can someone in the state and out of status whose mother is a citizen file for himself as a dependent, though not direct married? If yes, can the person get work permit? First and foremost, you cannot even petition for yourself. That's not possible under immigration law. You cannot petition for yourself. Secondly, I presume that this person who wrote this question is an adult. So if you are an adult, you don't qualify as an immediate family of a U.S. citizen. So that's another thing. So even though your mother can petition for you, if you are not married, your mother can petition for you as an unmarried child of a U.S. citizen. But it seems that this information is saying that you are married. So because you are married, your mother can still petition for you as a married child of a U.S. citizen. However, this type of petition is not considered immediate family. So this is one of those petitions that have to go through visa bulletin. And if I recollect currently, processing time or waiting time for this type of petition will probably be close to 10 to 13 years. Can you quickly help me check married child of a U.S. citizen? Visa bulletin for married child of a U.S. citizen. So I'll give you that information before we close today. But generally, you are not qualified as how many?
July 1st, 2010.
Okay, so that's about that's for more than 14 years. So the waiting period for that category is 14 years plus. So, and you cannot even file while you are on the queue. It is only after visa becomes current, which according to visa bulletin right now is about 14 years and 1 month. It is only after that you can apply for work authorization and all of that. But because visa is not current and you are not considered an immediate family member, you cannot apply for work authorization. You cannot even apply for green card or apply for anything based on that petition. The next question, please move forward. Move up, please. Oh, that's the one I just answered now. Yeah. Okay, the next question. I don't understand. So if you are undocumented, you can file tax. Really? How, sir? So can file without Social Security. How does the question start by saying I don't understand? I've not said anything about tax today.
There was a question last week.
Oh, it was a question last
They
week.
were asking if
Okay.
they had to file taxes if they were undocumented.
Okay, let me say this. Anyone who lives and makes income in the United States are eligible to file taxes. It does not matter whether you are documented or undocumented. Anyone who is making money in the United States is required to file taxes. Even those who do not live in the U.S., but they are making money in the United States, they are required to file taxes. It is mandatory. In the United States, only two things are certain. Anyone who lives in the U.S., or even if you live outside the U.S. and you are making money in the U.S., only two things are certain: debt and taxes. Nobody can escape those two things. So it does not matter whether you are documented or undocumented. Everyone is required to file taxes. But let me go further. If you are undocumented and you file taxes, it will actually help you, because if you eventually qualify for what is called cancellation of removal for non-permanent resident, filing taxes will show good moral character. Not filing taxes will be evidence of lack of good moral character. The next thing I want to say before I move to the next question, you may be wondering, how do I file tax? I don't have Social Security. I don't have legal status. Yes, you can still file taxes. The only thing is that you will not be able to e-file. You cannot file your taxes electronically. But if you want to file your taxes and you do not have legal status, what you need to do, make sure that you contact qualified tax preparer. I mean, There are people in my office who provide tax if you want to use their service, but it's not mandatory. But make sure you see qualified tax preparers. Once they file the tax, they will get a copy of the biometric page of your passport, and they will apply for what is called ITIN, and they will file it, the application for the ITIN, together with your tax return. They will file it by mail to IRS. So IRS will issue ITIN number for you, and they will process your tax return. And I guarantee you, if you have to apply for anything in the United States that requires you to prove good moral character, it will help you tremendously. I've seen a lot of people who are eligible for cancellation of removal. They've been living here for more than 10 years. For cancellation of removal, you need only 3 requirements. You have to show that you have been here for not less than 10 years. You have to show that you have a U.S. citizen qualifying relative, that is U.S. citizen parent, child, or spouse, who will suffer extreme hardship if you are to be removed. And finally, you have to show that you are a person of good moral character. And I've seen cases that were denied by immigration judges because people did not file their taxes, claiming that, oh, I didn't have Social Security, I didn't have this. That is not an excuse. Anyone making money, whether you live in the US or not, if you are making money in this country, you are eligible to file your taxes, and you can file taxes. I've represented clients who do not live in the US, but they transacted business in this country, and I've helped them to file their taxes. There is something called Form 1040 NR. NR means non-resident. Even foreigners who are making money here, they still have to file taxes. Even if the people who have never been to the US, they still have to file taxes. For as long as you are making money here, the only thing is the form that you file is different from those who are living here. Those who are living here, they file regular Form 1040. Those who are not living in the US, they file Form 1040 NR, non-resident. So not having legal status, not having Social Security, that is not an excuse not to file taxes. If you have been using that as an excuse, you better change, because the disadvantage may be waiting for you in the future, especially with all these new forms. To be honest with you, they just rolled out this new form on Monday, 2 days ago. I've not had time to evaluate it. But if, judging from what Donald Trump did in 2017 during his first term, when he required those who are applying for permanent residence to show their education, to show their credit history, to show everything about themselves. If those questions are reintroduced, like I said, I've not had time to review these forms. I don't know if those questions are there or not. But if those questions are reintroduced, if you have been here and you have not filed taxes, that may even be a ground to deny your green card. Because even the application for green card itself has been updated, and all these questions are already included. So you better stop giving excuses for not filing taxes, because ignorance of the law is not an excuse. The fact that you have been dealing with one roadside tax preparer who doesn't know what he or she is doing, and they are telling you that you cannot file taxes, you better seek advice from professionals who can do it the right way, so that this does not work against you. The next question, please. Okay, the next question. Please, the EO for college students who finish their bachelor's in political science and wants to go to law school immediately after, can the person benefit from the EO that students who finish college can apply for green card? I don't understand what you mean by EO, executive order. No. There's no such thing. There's no executive order that can give green card. This person is probably getting one information incorrectly. In the United States today, there is no executive order that can give green card. this person is probably listening to one of those fraudulent information on social media. There is no such thing. Nobody, no president, and even Donald Trump has not attempted it. No president can give green card by executive order. That is not possible. The next question, please. Okay. Asylum seeker with a daughter, but now thinking of getting married to a citizen. What will happen to my daughter if I drop my asylum application? Again, this question is not complete. Please, when you send question, remember I'm not a magician. You have to provide enough information that will enable me to answer the question. You have a daughter. How old is your daughter? I don't know. This will impact my answer. For example, if your daughter is less than 18 years, if your daughter is under 18 years at the time that you get married, your spouse, the application that your spouse filed for you, your spouse will be in a position to also petition for your daughter. Because as at that time, stepchild relationship will kick in. But if your child is already 18 and above, any marriage that you do will not protect your child. Any marriage that you do at a time that your child is already 18 years old, such a marriage will not protect your child. But if your child is under 18, the petitioner, your spouse that you marry, can petition for you and petition for your child at the same time. The next question, please. Good day, Dr. Asekun, and thanks for the great help to immigrant community. Is there a reason why H-1B wife dependent filing N-400 get interview before principal? H-1B?
I'm thinking they were on H-1B and then eventually got green card and now applying for citizenship. What would they call her first instead of him that was the principal?
Well, again, I'm just going to answer this question based on my thinking and assumption, because these questions are not very clear. I mean, number one, H-1B cannot apply for N-400. N-400 is application for citizenship. Only green card holders can apply for citizenship. But assuming that what my team members say is correct, assuming that this person is talking about obtaining green card as an H-1B and then eligible for citizenship and then apply for citizenship and then they call the wife first, that is not unusual. Let me tell you, citizenship application is individual application. This is not a marriage-based application. If you obtain your green card through H-1B, that is employment-based. So this is not a family application. So your citizenship application and your wife's citizenship application, they are two separate applications. And a lot of things determine when an applicant is interviewed. Number one, and the most important, is background check. So when they run a background check on you and when they run a background check on your wife, they are not going to find exactly the same thing. So it depends on a lot of factors. So background check on you can take maybe 4 months. Background check on your wife can take 2 weeks if there is nothing to check. For example, one of the things that affect background check, if you have visited multiple countries outside your home country and outside the US, of course, for those who process consular processing, you will see that whenever they ask for police clearance certificate, they always ask for police clearance from every country that an applicant has lived since age 14. So when they run a background check, they are going to run it based on every single country you have lived since age 14. So maybe your wife has not lived in any other country. Maybe your wife came directly from her country to the US. Maybe your wife is not a member of any organization, political or professional. Maybe your wife's life is so straightforward. So many things can affect it, but it is an individual application. So it is whoever background check clears first that get to be invited first. So it is not mandatory that because your wife got green card as your dependent, therefore your own citizenship is going to be faster. No, it doesn't work that way. Citizenship is an individual application and is treated individually. The next question. We still have this much question. It's already 21 minutes past our time. Okay. The next question.
Can you lower your microphone a little bit from that side? It covers your whole face.
Oh, okay. Oh, since when I've not noticed that?
I just noticed it.
Okay.
There.
Oh,
Not that much. There.
it's still the same thing. Okay. What if we do it like? Does it make a difference?
Yes.
Okay, like this. Okay. So the next question. Good day, doctor. Can green card holder travel to Nigeria with all what's happening now, sir? Oh yes, a green card holder can travel for as long as you don't have criminal record, for as long as you didn't obtain the green card fraudulently, and of course, for as long as you don't have anything that can trigger removal proceedings based on all the rules that have, all the policies that I've listed today. I don't know if whoever sent this question joined us from the beginning. For the purpose of those who are just joining, I mentioned today all the categories of people that the new policy requires to be placed in removal proceedings. And one of them is that even if you are suspected of terrorist activities, if you are suspected of fraud, you can be an NTA can be issued against you and you can be placed in removal proceedings. So if you don't have anything in your background that calls for concern, yes, you can travel. And of course, this person also didn't say whether this is a 10-year green card or a conditional green card. One thing I will tell you, if this is a conditional green card and the green card is based on marriage, you have to put your house in order before you travel. You have to put your house in order. What that simply means, your spouse must know your whereabouts. If you are not together with your spouse, you may consider suspending your travel for now. The next question, please. Good afternoon, sir. I'm bringing myself to the attention of the government when I request FOIA. How soon can I request FOIA if my child will be filing for me in February 2026? I don't think so. I mean, applying for FOIA, the thing is, under this current administration, everybody is already at the attention of the government because remember, there is public record. There is public record. You cannot live, well, I don't know which state you live in, but basically, you can, in most states in the United States, you cannot live in the US without driving a vehicle. And if you have a vehicle, it's public record. You cannot live in the US without having a phone. If you have a phone, it's public record. You cannot live in the US without having an ID. If you have an ID, it's public record. You cannot live in the US without going online, even if it is to buy something on Walmart, on Amazon, on any website. Those are public record. So you are already in the attention of the government. So if you are in a position to do something that will benefit you by requesting a FOIA, by requesting your file, I don't think that will deter you from doing it. However, if the main purpose is for your son, who is still going to turn 21 in 2026, if the main purpose is for the purpose of that petition, you can wait maybe until about 6 months before. But again, remember that there will be a processing time. FOIA is not just you apply today, they send it to you tomorrow. So you also need to consider the processing time. But if the only reason you want to apply for FOIA is just for you to apply based on the petition by your son, who will be turning 21 next year, I will suggest that you wait 6 months before your son will turn 21 before applying, so that in case something happen, at least within the 6 months, your son will turn 21 and quickly file a petition on your behalf while you are still fighting whatever happens. The next question. Good evening, Dr. Shegun. Sir, I have petitioned for removal of condition on permanent residence, which expired in 2023. I was issued a 48-month travel document and employment authorization document. Can you please move it forward so that I can read it?
No, that's another question.
And there is no follow-up?
No. Let me see. No. No. Okay.
Even after we stopped?
No, there's no.
Because this one does not have any questions, so what am I supposed to answer?
It says, I have petition for my removal conditions on permanent residence, which was expired in 2023. I was issued a 48 months travel document and employment authorization document.
Wait, that's different from what mine reads.
Do you have the full question?
Mine says, good afternoon, attorney. I petitioned for removal of condition on my permanent resident card in 2023. My form I-551 was extended by 48 months. Biometric data capture was conducted, and that was all till now.
Maybe I don't think.
But there's still no question.
No. I mean,
Okay, go to the next one, since this one does not have questions, so there's nothing for me to answer. The next question. Sir, what if they send the notice to our old address because we did not receive it? They now send removal proceedings to our new address. What can we do? Well, if you have the if you have the NTA in the new address, just find a way to defend yourself. Hire a lawyer. Look for a relief that you can present. As I've stated at the beginning of this podcast, under the new policy, it does not matter whether you receive the notice to appear or not. It is enough for immigration to have mailed the notice to appear to the last address that they have. Remember, by law, this is actually not about Donald Trump administration. Generally, by law, every U.S. citizen who is every non-citizen is required to notify immigration if they change their address. That is law. So if you move and you did not change your address, that is your fault. But in the past, we are able to show to the immigration court that this person actually did not receive the notice. But now, the new policy is saying that whether you receive the notice or not, it is immaterial, for as long as the notice was mailed to the address they know. And as I told you, most addresses, especially for mails that are not sent by certified mail or any form of mail that require proof of delivery, it is possible that you may not even change your address and you still may not get it, especially for those who live in apartments. I've seen cases of people who did not receive mail, yet they didn't change their address. But under the new policy is saying that it does not matter. For as long as USCIS can show that they mail it, that is enough under this new policy. And that is one of my fear. That is one of my greatest fear for this new policy. The next question. Good day. I have applied for asylum since 2017. I have not been called for interview. My question is, what can I do to make USCIS call me for interview? This is a very good question. However, before you do something to make USCIS call you for interview, the first question you need to ask yourself, are you eligible for asylum? Is your case a strong one? if you make them call you quickly for interview, are you sure you are not quickly sending yourself into removal proceedings? So those are the questions. If your answer to these three questions are no, then what you need to do, apply for expedited processing. Now, when you apply for expedited processing, USCIS will place you on a list for those who cancel their appointment or those who request a reschedule of their appointment. Usually, anyone who is on the waiting list for expedited processing, they are usually called for interview without notice. Today is a Wednesday. They can call you today on your phone and tell you to come for interview tomorrow. They can call you today and tell you to come for interview on Friday. They usually don't give notice because remember, they are filling in the gap for those who call to reschedule. They are substituting you for those who could not attend their own interview and decided to cancel. So most times they don't give notice, but it is possible to request expedited processing. But before you do so, answer those questions. Are you eligible for asylum? 2, is your asylum application a strong one? And 3, do you have all the supporting documents ready before you expedite yourself into removal proceedings? The next question. Okay. I and my family were referred to immigration court by USCIS after my asylum application was not approved. Was in removal proceedings from 2019 until December 2023 when case got dismissed by judge through prosecutorial discretion. I currently have EAD valid until July 2025. What will you advise I do next? Well, I'm going to advise that you consult an attorney. I mean, since you were previously in removal proceedings, I want to believe that you probably have an attorney. Go back to your attorney and review your options, because if you don't have a relief, you don't want to take any chances. Because as I said before, during Biden, yes, even weak asylum applicants, cases were being dismissed in court. I mean, I got a lot of cases dismissed, cases that I know that if we were to go into trial, those people are not eligible for asylum. In fact, there were cases of people who didn't have a clue what asylum means. They just got advice on the street, advice from friends, advice from people who have no understanding of what they are doing, and then they apply for asylum. But during Biden, these cases were dismissed because these people do not have criminal record. But now, if you do anything at all that brings that case back to the immigration court, if you do not have a ready relief, you may be on your way out of the United States. So I will advise you, sit down with your lawyer and look at your option. And if you don't have a lawyer, you may want to contact our office and we will go over the details of your case and then advise you the best way possible. But don't jump at applying for renewal of employment authorization without having a steady relief, because if you do, based on this new policy, once they deny your application for employment authorization, notice to appear is going to follow.
Okay, so the person that you said that there was no question,
Yes.
he has sent a follow-up one. This is
Oh, I see. Is there any reason to be scared?
this one.
Can you go back to the first one?
it
Let
the
me
one that
let me
found-
link the two.
Okay. This is it.
Okay. Good afternoon, attorney. I petitioned for removal of condition on my permanent resident card in 2023. My form I-551 was extended by 48 months. Biometric data capture was conducted, and that was all till now. Is there any reason to be scared if my removal of condition on permanent resident is still pending after my 2-year permanent resident card had expired since 2023, although I have I-797 with a 48 months. No, there is no reason to be scared. However, what I will do if I'm in your shoes, what I will do is to put my house in order. Since this is based on marriage, ensure that you are in a good relationship with your spouse. Ensure that all of the evidence of your relationship are intact. Ensure that there is no adverse information that can come up regarding your marriage. If all of these things are in place, if your application has been pending for, even based on that information, I think the application has been pending for more than 1 year. Then, if all those things are in place, it simply means that you are already eligible for citizenship. You can go ahead and file your application for citizenship. On the other hand, if you are not together with your spouse, it is better to divorce. Separation will not help you because separation may trigger evidence of fraud. So it depends on your situation. You are the only one that knows how your marriage is currently. But a lot of answers to this question, whether you have reasons to be concerned or not, a lot depends on your marriage, on the status of your marriage. But if everything is okay, nothing to fear. There's no worry. But if everything is not okay, you want to quickly make sure you work on your marriage or you do the needful if you are not together. Remember, when I started with this new policy, I started with mandatory issuance of NTA. And one of those mandatory issuance of NTA is where a removal of condition is denied. So if this application is denied, you may find yourself in removal proceedings. So in order to prevent the denial, make sure you put your house in order. If you are still together with your spouse, make sure you continue to accrue evidence of your relationship. Continue to commingle your assets, joint lease, joint bank account, utility bills, joint travel, joint everything. Continue maintaining good relationship with your spouse. On the other hand, if you are no longer together, it is better you end it. If you are separated, that will trigger investigation into fraud. So you may want to end it and then request USCIS to consider the petition on the basis of good faith marriage instead of joint filing. The next question, please. Okay. Hello, sir. What's your advice on those people who entered the USA through the border and married a citizen to change their status from seeking asylum? Can their status be changed through that? Well, only if they were paroled. Only if they were paroled. Anyone who entered the United States through the border without visa, they cannot adjust status in the US. They can only adjust status if they are paroled. If they are paroled, yes, they can adjust status. But even then, there are some paroles where it is clearly written on the parole that this person cannot adjust. This parole is not for adjustment purpose. If that is the kind of parole that you have, you cannot adjust. But if you are paroled and the parole does not have limitation, you can adjust your status in the US. On the other hand, even if you are not able to adjust your status, if you are married to a US citizen, the US citizen can file I-130 petition on your behalf. If that petition is approved, then you can apply for what is called provisional unlawful presence waiver. Provisional unlawful presence waiver. If that waiver is approved, then you do consular processing. You go back to your home country, go to the US embassy, and then you get your immigrant visa and come back as a permanent resident of the United States. The next question. Thank you, Dr. Olu. Please, what is the remedy for someone who is out of status, non-immigrant since 2020 and without any criminal record? If you have been out of status, unfortunately, I don't have any remedy for you, because once you are out of status, you cannot change your status, you cannot adjust your status. Since 2020, you cannot even apply for asylum, even if you are eligible. There is really nothing. The only thing left for you is marriage to a U.S. citizen. The next question. My spouse is a U.S. citizen and we got married in December 2024. She filed her 2024 tax return as single in February 2025. Would that affect the adjustment of status affidavit of support eligibility? Yes, it will. IRS is an agency of government. USCIS is an agency of government. You cannot tell one agency of the same government that you are married and tell another agency of the same government that you are single. Yes, it will affect it, especially in this era of enhanced immigration scrutiny, benefit scrutiny. Yes, it will affect it. The next question.
But wait, they married in December of that year.
Okay, go back to the question.
Because they married in December of 2024. So she filed a
Oh, that was just last year.
Yeah.
Oh, thank God for bringing that to my attention.
Yeah.
Sorry, I missed that. This was a marriage of December 2024. Okay.
Yes.
Single will not affect it because this is a tax of 2024.
Yeah.
This is a tax filing for tax year 2024. So since you are not married for most of 2024, your wife can still legally file as single, because for somebody to file as married, you must have been married for at least half of the year. But since your marriage is December of 2024, you are only married probably for less than a month. Yes, she can still file 2024 tax as single. Yeah. Please, thank you for bringing it to my attention.
But next year for sure.
Yeah, but of course, next year they will have been married the whole year. This is just because they have been married for a month. Yeah, thank you for bringing the year to my attention. Thank you. The next question. Good afternoon, sir. Am I bringing myself to the attention of the government when I request for it? I thought I already answered this.
Yes.
They probably posted it.
This seems to be a continuation. Agency file, or is it? Okay, let me just read it. The next question. Agency filed my I-140 EB3 and was approved, and I'm no longer working with the agency. Can I file for myself? Again, this is not a complete question. This person didn't say whether the I-485 has been filed or not. If the I-485 has been filed and the I-485 has been pending for at least 180 days, you can change employer. You can change employer and still use the approved I-140. First and foremost, you cannot file for yourself because you are not an employer. EB simply means employment-based. So since your I-140 is employment-based, it means it requires an employer. The I-140 that was approved for your specific employer. However, if I-485 application for permanent residence has been filed after the approval of the I-140, and that I-485 has been pending for at least 180 days, 6 months, if you have a new employer, the new employer can take over the approved I-140. But if I-485 has not been filed, you cannot even do anything with the approved I-140. Next questions, please. The next question.
This
The
is
last
the
one.
question.
Thank God, because I see that we are almost 1 hour. We are already 1 hour 45 minutes, and we were supposed to be 1 hour. Okay. For asylum case that has been on, your next step is interview status. for so many years now. I'm thinking of filing mandamus lawsuit. What is your advice? As I stated, I don't know whether I told somebody this individually or it was one of my podcasts. You see, when you file a mandamus, you are throwing a stone. And there is a popular saying that he who lives in a glass house does not throw a stone. Yes, we file mandamus for delayed asylum cases, but mandamus simply means the court will tell immigration to adjudicate. Mandamus does not mean the approve or deny. Mandamus simply means mandate them, order them to adjudicate this case. That is the meaning of mandamus. So before you even think about mandamus, it does not matter whether it is asylum case, whether it is family based, whether it is employment based, whether it is any special circumstances. Before you think about mandamus, the first thing is this case approvable? That is your starting point. So if your case is very strong means that no matter what, you have overwhelming evidence that this case will be approved. Then you can file mandamus. But if your house is not in order, if your case is going to require immigration at one point or the other to use their discretion, you better don't go near mandamus, because that will backfire. He who lives in a glass house does not throw stone. So in this particular case, I'm not going to tell you yes or no, because I don't know the strength of your asylum application. I don't know how strong your case is. But if your case is such a strong one, yes, you can file mandamus. Well, I hope. How many more questions do we have?
Wait, yeah, let me take all the questions. I want to do it on this phone.
Yeah, I see that a lot more have
There's
come.
at least 20 more.
Yeah, we are going to have to stop it at this time. It's almost 2 hours right now. Our viewers, I hope you will have to bear with me. This podcast was scheduled. This podcast was scheduled to be for 1 hour, and in the last few weeks, we have been exceeding the 1 hour because of the so many information that we have to provide while still answering questions. You will agree with me that it's a lot of time in this country. I mean, to give up 2 hours every day, in fact, it's more than 2 hours, because we have to do the preliminary setup and all of that, and we have multiple members of the team putting this together. Is a lot of sacrifice that we make every week. So you have to bear with us. If we are not able to answer your question this week, I can guarantee you that your questions will be the first set next week once we continue. I also want to advise you to subscribe to our channel so that once we go live, you are notified, because we have noticed that once we start this podcast, a lot of people log in midway into it, and then they tend to take us back. Everything that we have said at the beginning, all the information that we have provided at the beginning, all the questions we have answered at the beginning, they tend to take us back and want us to re-answer those questions. So if you subscribe, as soon as we log in, as soon as we go live, you get notification and you'll be able to join us immediately so that you don't miss out on any question. Again, invite your family, friends, colleagues at work to subscribe. That is the only way you can get the full podcast. And again, if you miss any part of the podcast, this podcast is recorded on our YouTube channel. You can go back and replay it and listen to it at your convenience. So for now, I want to thank you for joining us. You also, it is important that you also know that we have other social media outlets where we provide information. We provide short information on Instagram, on Reel, on TikTok, where we also provide information. So we do all these things free of charge with no strings attached. So the only thing you can do to show appreciation is to let others benefit from this. Thank you again for joining us. We also want you to know, if you are based in Texas, we also do personal injury. Personal injury. If you are involved in any form of accident, auto accident, and all of that, you can contact our office. That is another thing that it's another service that we offer, but only for those who live in Texas, because that is a state law. Thank you again. We hope to see you next week, where we will continue with this podcast. Until then, please stay safe. Avoid anything at all that can bring you to the attention of law enforcement officers in the wake of these new NTA policies. Until then, I remain yours truly, Dr. Olu